Hi, everyone. As educators here in Utah, we handle sensitive student information every day. Sometimes law enforcement might ask for access to that data. Knowing when and how we can share it legally is crucial. Today, we're focusing on the Family Educational Rights and Privacy Act, or FERPA, and how it applies when sharing student data with law enforcement officials, or LEOs. By the end of this short training, you'll be able to explain the requirements for sharing student personally identifiable information, or PII, under key FERPA exceptions, the school official exception, the health and safety emergency exception, and the subpoena exception. We'll also cover a few other circumstances and clarify the important difference between an educational record and a law enforcement record. Whenever student data is shared, the most important thing is ensuring we have the legal right to do so under FERPA. Generally, FERPA requires parental consent before sharing, but FERPA is nuanced, especially with law enforcement. Let's break down the exceptions that allow sharing without prior consent. There are three main FERPA exceptions we'll focus on for sharing data with LEOs: the school official exception, the health and safety emergency exception, and the subpoena exception. First, the school official exception. Who qualifies as a school official? Typically, it's school employees like teachers, counselors, or administrators who have a legitimate educational interest in accessing the data. It can also include individuals or companies the school has outsourced work to, like certain volunteers, contractors, or even some edtech apps, provided they meet specific criteria. Now, can an LEO be considered a school official? Yes, but under very specific conditions. The LEO must be performing a function the school would otherwise use an employee for. Think of an SRO specifically assigned to ensure school safety under the school's direction. The data shared must remain under the direct control of the school. The LEO can only use the data for the specific purpose it was disclosed, like that school safety function. They must meet the criteria outlined in your school's annual notice of FERPA rights. And crucially, the LEO cannot redisclose this information to anyone else, not even other LEOs acting outside that specific school function. So, before sharing under this exception, ask yourself, is this LEO designated as a school official for this task? Do they need this exact info for the job the school asked them to do? Is it the absolute minimum data needed? And, very importantly, does the LEO understand they cannot share it further? Next, the health and safety emergency exception. This applies when there's an articulable and significant threat to the health or safety of a student or others. Think of immediate dangers like a natural disaster, a credible campus threat, or a serious epidemic outbreak. When using this exception, the disclosure must be necessary to protect health or safety. Sharing is limited to the period of the emergency. Share only the data directly related to the emergency. Minimize it. And you must record in the student's education record what the emergency was and to whom the data was disclosed. This might be LEOs, public health, medical personnel, parents, or others who need to know to protect safety. Third, the subpoena exception. You can disclose student records if required by a lawfully issued judicial order or subpoena. Generally, the school must make a reasonable effort to notify the parent before complying, giving them a chance to take protective action. However, you are not required to notify parents if the subpoena or order specifically prohibits it, like an ex parte order. While FERPA doesn't mandate recording this disclosure, it's always best practice. Are there other ways LEOs might access data? Yes. Directory information. You can share data designated as directory information, but only if the student's parents haven't opted out. However, you may want to consider whether this is in the spirit of your district's directory information policy. Juvenile Justice Services. Data can be shared under specific state law provisions, usually requiring written certification from the agency that they won't redisclose it. and always written parental consent. This is the default. You can always share if you have explicit written permission from the parent. Finally, let's clarify a critical distinction: educational records versus law enforcement unit records. Educational records are records directly related to a student and maintained by the school or someone acting for the school. These are protected by FERPA. They generally cannot be redisclosed without consent or another valid exception. Law enforcement unit records are records created and maintained by a school's law enforcement unit for law enforcement purposes. These are not considered educational records under FERPA and are not protected by FERPA privacy provisions. Their release is governed by other laws and local policy. It's vital to understand that an SRO or LEO working within the school might handle both types of records. That's why best practice, and often policy, dictates that law enforcement unit records must be kept separate from educational records. So, let's recap the key takeaways. Always aim for written parental consent first. If using a FERPA exception, ensure all specific conditions are met before disclosing data. Remember the rules about redisclosure, especially that data shared under the school official exception cannot be shared further by the LEO. Keep educational records and law enforcement unit records clearly separate. Protecting student privacy while ensuring safety requires careful attention to these rules. Thank you for taking the time to understand how FERPA guides sharing student data with law enforcement. For more details and specific scenarios, please check out the resources available from the Utah State Board of Education Student Data Privacy Team.